Hello friends, in the series on the income tax cases, today we will discuss the issue related to the prosecution proceedings initiated by the department under section 276C, which talks about willful attempt to evade tax, and section 277, which talks about the prosecution proceedings in case when there is false statement by the assessee in verification. The issue has been discussed in the case of TVH Energy Resources Private Limited and others versus Assistant Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 433, and the matter has been decided by Honorable Madras High Court, and the date of the judgment is 13th July 2023. In the present case, when the assessment proceedings were going on, it was the allegation of the assessing officer that the assessee is not able to substantiate the source of some expenditure to the tune of rupees 1.19 crore that was done in cash, and hence the additions were made. And for that, not only additions were made, but the penalty proceedings were also initiated and were continuing against the assessee. At the same time, the department also initiated the prosecution proceedings against the assessee. In the present case, when the penalty proceedings were being before the Honorable Tribunal, the Tribunal found that there was no merit in the case of the assessee in the penalty proceedings because the assessee has substantiated the cash expenditure which has been done by the assessee. So the tribunal gave the decision in favor of the assessee as far as the imposition of penalty on the assessee was concerned. Now on the same issue, the department was contesting the prosecution proceedings. So when these prosecution proceedings were before the Madras High Court, the Madras High Court said that since on the same facts and circumstances, the tribunal has deleted the penalty proceedings, so the prosecution proceeding should also go. At the same time, it was the viewpoint of the Madras High Court that if the penalty proceedings are not sustainable against the assessee on the same facts and circumstances, so the prosecution proceedings can also not be initiated and continued against the assessee. When parting with the case, the Madras High Court discussed some basic principles of prosecution proceedings in the Income Tax Act. First of all, the court said that adjudication and criminal proceedings can be continued against the assessee simultaneously. Second, the court said that the decision in adjudication proceedings is not necessary before initiating the prosecution proceedings, meaning thereby that the assessee cannot take the plea that the decision in the adjudication proceedings, that is the quantum of the demand, is not finalized, so the prosecution proceedings cannot be initiated against the assessee. The assessee cannot take this ground, or in other words, we can say that if the quantum demand is yet to be finalized by the CIT appeal or the tribunal, at the same time the prosecution proceedings can go against the assessee. The conclusion can be drawn that the prosecution proceedings and the adjudication proceedings are independent of each other. The court said that adjudication proceedings by Enforcement Directorate are not prosecution proceedings by a competent court to attract the provisions of Article 20, Sub-Article 2 of the Constitution of India or Section 300 of the Criminal Procedure Code 1973. At the end, the court said that the nature of finding in the adjudication proceedings is very important for determining the prosecution proceedings against the assessee. For example, if the adjudication proceedings are decided in favor of the assessee because of some technical ground, like the DIN number was not there in the assessment orders or the orders was not passed in the limitation period, then these are technical grounds. And if the demand of the assessee has gone, or is not sustainable because of the technical grounds, so in that case the prosecution proceedings can continue, because the assessee has got the relief on the technical grounds and not on merits. In contrast to that, if the adjudication proceedings or the quantum demand is being given in favor of the assessee, or the quantum demand has been deleted by the various CIT appeal or tribunals, then in that case, if the quantum demand is deleted on the basis of merit, then in those cases the prosecution proceedings cannot be continued, because for continuing the prosecution proceedings the department has to prove beyond doubt that there was some malified intention of evading the tax by the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is TVH Energy Resources Private Limited and others and versus Assistant Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 433, and the matter has been decided by Madras High Court, and the date of the judgment is 13th July 2023. Thank you, friends.